afternoon, everyone. Thank you for joining us this afternoon for ScreenSkills hiring non-UK animators in UK's post-Brexit immigration system. I'm really delighted to introduce you to Anna Blackden and to Liz Kynaston, who are associates at Doyle Clayton Solicitors, and they're going to give you a brilliant overview on hiring non-UK talent. Anna, Liz, over to you. Thanks.
As Abigail said, I am an associate solicitor at Doyle Clayton and have been specialising in immigration law for nearly 15 years. So we act for many clients actually in the creative sector, and so we're really delighted to be invited by ScreenSkills to give this session to you. I'll just let my colleague Liz introduce herself.
Hi everyone. So yeah, I'm Liz Kynaston. I do both employment and immigration law at Doyle Clayton Solicitors, and I work with individuals and companies on, say, employment and immigration matters.
Just as we are lawyers, so we'll give a small disclaimer that the purpose of today's session is to give sort of general guidance only really about what Brexit means and the UK immigration system. You know, we can't sort of give specific advice tailored to your particular situation, but of course, you know, we have our contact details at the end of this presentation, and you're very welcome to drop us an email. But the purpose, and we'll hope you'll find it beneficial, is to give you sort of a general overview of the UK immigration system and how to hire non-UK animators in a post-Brexit UK. So just looking at the session outline, I'll just talk you through what we're going to be looking at today. So firstly, it's demystifying what Brexit actually means. 2019, all you heard about in the news was Brexit, but then 2020, all you heard about was COVID. But in that time, Brexit did still actually happen, and we have left the EU. So we're going to talk about what that means on a practical level in terms of hiring EU nationals. And linked to that is this EU settlement scheme, which I will explain in a moment. So we'll look at the new points-based immigration system that's been launched by the government post-Brexit, and the visa routes within that system, which will allow animation studios, for example, to hire professionals in the skilled worker as well as the creative worker visa routes. But there are also what we call non-sponsored visa routes, whereby someone could apply to come to the UK under, for example, a global talent visa, youth mobility. There's a new graduate visa. So we're going to look at all the main visa routes that you might see or might find useful when hiring people who do not have British nationality. And then what we've seen as an increasing trend during this pandemic is hiring staff who are based overseas, but to work remotely. So you don't need a visa, a UK visa for that, but it kind of raises all sorts of employment considerations, which Liz will discuss with you at that point of the presentation. So yes, that's our session, a brief session outline. Obviously, we'll canter through some areas more quickly than others. But firstly, looking at so Brexit and the implications for, you may have existing staff who are from European Union countries, or it might be a question of you're looking to hire a French national, for example, and what that now means post-Brexit. So the first point to make is that Brexit means that free movement of EU nationals ended on the 31st of December 2020. So what this means is there's no longer one system for EU nationals and a different system for non-EU nationals. So gone are the days where it would be sufficient just for an EU national to present their passport alone. So this represents one of the most significant changes to the UK immigration system in 40 years, because, and as you can see from the slides there, what it means is that from the 1st of July 2021, EU nationals will need to show a UK employer either that they have this protected status under the EU settlement scheme, which I'm going to talk about in a moment, or they have specific immigration permission to come to the UK, that they are subject to this new immigration system. And so it's really important to recognise that Brexit means that you effectively have these two categories of EU nationals. One category that arrived before the 31st of December 2020, and therefore their right to remain is protected and live and work and access the NHS. It's all going to be protected by this EU settlement scheme. And then the other cohort of EU nationals that arrive from the 1st of January 2021 are in a very different situation. And it's important to kind of bear in mind that distinction as we go through, because it's so significant. So looking now at the EU settlement scheme. So what is it? This is a scheme that anyone from the EU who has been living in the UK should know about this. It is a scheme for EU citizens and their family members who wish to remain in the UK after Brexit. It allows them to secure that right to stay and to enjoy all the benefits they've been benefiting from to date. So their family members could be non-EU nationals, but they would still have the right to stay as well. So you can see from that slide, the significant date there is the 31st of December 2020. That signaled the end of that 12-month transition period, the end of free movement, and was basically the deadline for those EU citizens to be resident in the UK in order to be eligible to apply to this EUSS scheme, EU settlement scheme. Because other EU nationals from the 1st of January 2021, they are subject to the new points-based immigration system. Now, the 30th of June 2021 date relates to, there's a grace period whereby EU nationals who were in the UK by New Year's Eve 2020 have an extra 6 months to be able to make that EUSS application. And that's significant from a right to work perspective, which Liz is going to talk about in a moment. So just to give a little bit of an overview of this EUSS application process, it's free, it's online, and what you get is if you apply to the EUSS scheme and have been living continuously in the UK for 5 years already, you get granted settled status. If you haven't been here 5 years, in fact, if you only arrived on the 30th of December 2020, you still arrived and you would get pre-settled status, and then you could upgrade that and apply to settled status at the point you've been here 5 years. Hence why the deadline for citizens to first apply is that 30th of June 2021. And EU nationals have been applying in huge numbers. I think as at the 31st of December, already the government had received 5 million applications to this scheme. So it's important that they apply, because otherwise after the 30th of June 2021, they could end up with no legal right to live or work in the UK. It does not apply to Irish citizens who have separate rights to live and work in the UK. So what Liz is going to look at now is, as an employer, what right to work checks you need to take of an EU national. So I'll let Liz take over at this point.
Thanks, Anna. So lots of clients have been asking about carrying out right to work checks on EU nationals. So we just thought it would be helpful to kind of give a quick overview of what documents you need at the moment and going forwards. So as you'll be aware, UK employers need to ensure that all staff have the right to work in the UK. Now, pre-Brexit, it was fairly straightforward. You could just ask your EU national staff to prove their right to work by giving you either their passport or their EU national identity document. And that's still the case until the 30th of June 2021. An EU national can prove that they have the ongoing right to work in the UK just by giving you their passport or national identity card to do a right to work check on. Alternatively, they can give you evidence that they have settled or pre-settled status. So in practice, that will mean them sharing the details with you so that you can carry out normally an online right to work check. But it's really important to note that you can't require them to provide that evidence until at the moment. So if they start before the 1st of July, if they want to just give you their passport or national identity card, then you have to accept that as evidence of their right to work in the UK. So then from the 1st of July, as you'll see on the slide, the position changes. So any EU nationals who start a job at your company from that date will need to provide you with evidence that they have settled or pre-settled status. If they can't, or I should say, or that they've got immigration permission under a different immigration route. So, for example, they've got a skilled worker visa, etc., which we'll talk about shortly. If they don't provide you with that evidence, you won't have proof that they have the right to work in the UK, and so you shouldn't employ them. Otherwise, you could face illegal working penalties. Now, something that's really important to note is that the government has said that they don't expect you to carry out retrospective right to work checks on EU nationals who joined you before the 1st of July. So it's sort of quite reassuring, I think, for employers to know, because I think lots of people were panicking that they would have to make sure that all of their staff had applied for settled or pre-settled status, and that's not the case. The government has said that you don't have to, although you can if you want to, but if you do want to ask staff for that evidence, then you need to do so in a non-discriminatory way. We would recommend that at the very least you ask any existing EU staff to, you remind them, you tell them about the 1st of July deadline. So you should send an email out to all staff, not just EU nationals, so to everybody, reminding them about that 1st of July deadline to apply for settled or pre-settled status, encouraging people to do so. And you can also ask them to send you evidence of settled or pre-settled status and say that would be kind of helpful for your business planning purposes, but you can't suggest that's mandatory. You can't require them to provide that evidence. But I think probably in practice, lots of staff will provide it. And it's good to try and get that evidence now, because just to explain, so you don't have to carry out retrospective checks, but if, for example, you were employing somebody and they started in March 2021, they gave you their passport, that would be fine. That's sufficient evidence of the right to work in the UK. However, if in October you found out that they hadn't actually applied for settled or pre-settled status, you would then know that they didn't have the right to work in the UK because they hadn't obtained that settled or pre-settled status, and then you might have to dismiss them. So it's much better to remind staff now to apply under the scheme if they're eligible, to avoid future employment law headaches. And just finally, just a reminder at the end of the slide that any EU nationals who arrived in the UK from the 1st of January 2021 usually won't qualify for pre-settled or settled status, and so will need to have permission to stay in the UK under a different immigration route. And as I said before, until the 30th of June, you can't require them to provide that alternative evidence. But if, for example, somebody joins you next week who you're sort of not quite sure because their CV suggests that until February this year they were working in Spain, then that's the kind of situation I would recommend that you take employment law advice about how to take things forward. And also just to mention that the government hasn't really provided much guidance about carrying out EU checks, right to work checks on EU nationals from the 1st of July, but they have said that they'll publish new guidance on that at some point before the 1st of July. So, right, moving on then. So, as Anna mentioned, we've got a new points-based immigration system, and that was launched on the 1st of December 2020 and applies to all EU nationals who arrived in the UK from the 1st of January 2021. And it's really important to note that it treats EU citizens and non-EU citizens equally. So they need to meet the same requirements. And any EU national coming to the UK from the 1st of January will need a visa to work or to study here. And as Anna already mentioned, Irish nationals are the exception. They don't need to get a visa to work or study here. They can continue to come as they always have. And finally, just before we go forward into the different visa categories, just a note that any UK businesses wanting to sponsor an overseas worker will need to be a licensed sponsor. Right, so on this next slide, we've got a summary of the key sponsored visa routes. So there are two types of visa routes largely. There's the sponsored routes and the non-sponsored routes. As a company, if you want to sponsor somebody under one of the sponsored visa routes on the slide, you will need to have a sponsor license. So as I say, we've got a few examples of the sponsored visa routes, but we've got the skilled worker route, which allows employers to hire skilled workers, specialist individuals, to come to the UK to fill permanent roles. You've got the temporary worker and creative and sporting route, which, as the name suggests, can be used to bring someone to the UK or to sponsor somebody that's in the creative industry, or less relevant here, who's a sports person. Then you've got the intra-company transfer route, which lets companies bring over staff from overseas offices to fill a sort of temporary vacancy in the business. And then less relevant here, the health and care worker visa, which is aimed at medical professionals coming to join the NHS or similar. And then student visas, which, again, as the name suggests, lets people study in the UK. So the ones that are probably going to be most relevant to animation studios are the skilled worker route and the temporary worker creative and sporting route. And so Anna and I are going to give you a bit more information about both of those routes shortly, so the requirements, the application process, etc. Now, moving on to the non-sponsored visa routes. So these are all routes that an individual can apply for themselves. They don't need to have a job offer. They don't need you as a company to sponsor them to get this type of visa. So there are quite a few on this slide, but I think probably the main ones that you're likely to encounter are the Global Talent Visa, which is for leaders and potential leaders in certain areas, including arts and culture. Then you've got the graduate routes, which will let recent UK graduates or graduates from UK universities stay here to work. You've got the UK Ancestry Visa, which lets individuals from a Commonwealth country who've got a British grandparent or a British-born grandparent come to the UK to work. And then you've got the Youth Mobility Scheme Visa, which lets 18 to 30-year-olds from certain countries come to the UK for up to 2 years. So now that we've gone through the main visa routes, I'm going to hand over to Anna, who's going to tell you a bit more about sponsor licenses and how to apply for one.
Thanks, Liz. So as we've seen, there are a number of visa routes which would allow someone to come to the UK, but they require their employer to sponsor them. So we appreciate that there may be some attendees who work for a company whose employer already holds a sponsor license. But if it doesn't, then holding a sponsor license will be key to opening up the potential to hire under a number of other visa routes, namely the creative worker or the skilled worker visa route. So what do you need to do to get a sponsor license? Well, you need to apply online. It's an online application process. The fee is either £536 or £1,476, depending on the size of the employer. And then what you would need to do is send certain supporting documents to the Home Office, which basically show that you are trading and based in the UK. So it'd be documents like your corporate bank statement, your company accounts, your VAT certificate, PAYE certificate, as well as details about the kind of roles that you would want to hire nationals for. So you would say, oh, well, I have a CG supervisor role and an animator role. And so you would say that you work in the creative sector. So you would give details about why you need to hire non-UK nationals. Now, what we've seen is that there's obviously various sponsored routes. And there is so you would ask for the license in various categories, such as skilled worker, creative and sporting, or there is also the student category. But what being a licensed sponsor actually means is that you can assign this all-important COSS, which is an acronym for Certificate of Sponsorship. And for these sponsored visa routes, a COSS number, Certificate of Sponsorship number, is absolutely mandatory. Without it, their visa application would fail. So that is what sponsorship or having a sponsor license brings you, is your ability to assign a certificate of sponsorship. But with the benefits that migration comes and the ability to hire these highly skilled migrants that your business needs, comes a sense of shared responsibility, that the whole sponsorship system is underpinned by this principle that you're benefiting from migration, but you then have a duty to help us support immigration control. So it does come with certain sponsor rights and obligations as well, which a sponsor needs to be aware of. But certainly it's interesting to know that there are at the moment over 30,000 UK businesses who hold a worker sponsor license. And just in the 3 months since January, there's been a surge in applications with businesses recognizing, hey, we actually need one of these sponsor licenses now post-Brexit. So I think there's something like 33,500 businesses with this Home Office sponsor license. So looking now at, oh, and so sorry, the last point in that slide was there are certain cost implications, of course, of sponsoring non-UK nationals. And we will look at the costs when we look at the creative visa route and the skilled worker visa route. But not only is this the sponsor license fee, but then there are various costs of sponsorship. And so, of course, that does need to be factored in. But Brexit does unfortunately mean that it is going to cost more to hire a non-UK national potentially if it's down the sponsored visa route. And that's why we will see the potential advantages of being able to employ someone on the non-sponsored visa route. So potentially someone on a youth mobility visa that can work for you straight away doesn't have the same cost implications of saying, well, you've found the perfect person, but you need to hire them under the skilled worker visa route. But we will look at that in further detail in terms of what it means and what it costs to use these visa routes. So looking at the next slide now, and in terms of looking into a little bit more detail about sponsoring animation professionals. So firstly, you would need to be a licensed sponsor. Then one visa route is the skilled worker visa route, which is essentially for any non-UK national with a job offer from a licensed sponsor. And crucially, as Liz will look at in a moment, they have to meet certain minimum skill and salary thresholds, as well as being able to speak English to a minimum standard. So these are all very important factors to bear in mind whether they're even eligible for this type of sponsorship. Otherwise is the T5, the T stands for tier 5. We used to have a sort of a number of tiers that was referred to in the previous immigration system. So tier 5, creative and sporting visas. Now this visa route allows individuals in the creative industry to work for a licensed sponsor, again, needs to be licensed, for up to 12 months, with the option to extend up to 2 years. But so it is a more of a temporary visa route rather than the skilled worker visa route. But we're going to now look at those visa routes in a little bit more detail. So Liz is going to kick off first with the skilled worker visa route.
Great, thanks, Anna. So as Anna said, I'm going to talk now about the skilled worker visa route, and that was previously known as the Tier 2 general route, if you've heard of that name. So, right, here we go. On the next slide, we've got a list of the key requirements for sponsorship under the skilled worker route. So as it says there, the applicant needs to score 70 points, and I'll go through each of those in a moment. Just to mention that as well as meeting those 4 requirements shown on the slide, the individual will also need to meet the financial requirements. So they will need to show that they have funds of at least £1,270, or their sponsor will need to certify that they will maintain them for up to the first month of their employment in the UK if needed. And in practical terms, that's not too difficult. Normally, the employer will just tick a box on the person's certificate of sponsorship confirming that they will maintain them if needed. But if the company isn't prepared to do that, then the individual will need to prove that they've got that level of savings. Right, so as I said, the applicant needs to meet those key 70 points. So to qualify for sponsorship, they will first need to show that they have a job offer from an employer with a sponsor license. Then they will need to meet the English language requirements to score an extra 10 points. So a person can do that in a number of ways. So they can be a national of a majority English-speaking country, so the US, Canada, New Zealand, etc. Or they can have a degree from a UK university, or a degree that was taught overseas but was taught completely in English, and they would need to get a statement from an organisation called UK ENIC confirming that. Or the person can pass a Home Office approved English language test, or they can prove that they met the English language requirement in a previous immigration application. But I think it's really important to note that this is a big change for EU nationals who obviously didn't previously have to show that they met a minimum English language requirement. And it's not so much being fluent in English, that's not so much the issue. It's just that the Home Office is very kind of prescribed ways that you have to do that. And it might be, you know, someone could be fluent in English, but they'll still need to prove that they have that UK degree or degree taught in English or take the test. So third, the individual must have been offered a job that is at an appropriate skill level by their UK sponsor. So the Home Office classifies different jobs into different what's called occupation codes or job types. And it has a list of all of the jobs, all of the occupation codes that qualify for sponsorship online in a document called Appendix Skilled Occupations. Now, the roles that qualify for sponsorship are all classified as at RQF level 3, which basically means A-level level. And it's really important to note, though, that the individual doesn't need to have an A-level qualification or overseas equivalent or higher. It's just that's the level that the Home Office classifies the role at. And last, and this is where it gets slightly more complicated, the job needs to score 20 tradable points. So often that can be quite straightforward. So you will score 20 points if the salary for the role is £25,600 per year, or what's called the going rate for the occupation code, whichever is higher. Now, each occupation code has a going rate, and that's based on the market rate for the particular type of role. If the salary doesn't meet that first standard rate, it is still possible to sponsor a person in some circumstances and to offer them a slightly lower salary. So a person can be paid slightly less if they are classified as a new entrant, and that can apply if they're aged under 26 at the time of applying, and if they're being offered a salary that is the higher of £20,480 per year, or 70% of the going rate of the occupation code. And another option which may well be relevant to you is if the role is on the shortage occupation list, and I'll come back to that in a moment. But if the role is on the shortage occupation list, again, you can pay slightly less. So the salary for the role will need to be the higher of £20,480 per year, or 80% of the going rate for the occupation code. So as I said, I'll talk a bit about the shortage occupation list. So you'll see on this slide, we've got a summary of some of the types of role that might be relevant to you that fall onto the shortage occupation list. And the shortage occupation list is really a list of roles or types of roles that the Home Office recognises can be really hard to recruit from within the UK, and there just often aren't the skills in the UK workforce to sort of meet the requirements. And so the Home Office kind of acknowledges that they can sort of make it a bit more attractive, a bit easier to sponsor somebody for these types of roles. So as you'll see, for example, occupation code 3411 is for artists, and that could cover an animator. So the real benefit of the shortage occupation list is, first of all, as I mentioned before, you can potentially offer a slightly lower salary. So the higher of £20,480 per year, or 80% of the standard going rate for that particular code. Another big advantage of a shortage occupation list role is that the application fees are slightly lower. So again, if you've got a role that could fall onto the shortage occupation list, that's great, because it means there'll be some slight savings. Right, so now we just thought it would be helpful to give you a quick overview of the application process for a skilled worker visa. So as you'll see on the slide, if you want to sponsor someone who is already in the UK, then you will first of all need to assess whether the role qualifies for sponsorship and whether the person qualifies for sponsorship. If they do, you can then assign what's called an undefined certificate of sponsorship to them on your online sponsor. And then once you've done that, the individual can submit their online application form, upload their supporting documents, and attend their biometrics appointment. So that will be where they give their fingerprints and digital signature and photograph. The standard processing time for a skilled worker country made in the UK is 8 weeks. And if the person needs to have their application dealt with more quickly, for example, if they need to travel or whatever, then they can use the priority processing service, which costs £500, and the application will be processed in 5 working days. Or they can use the super priority service for an extra £500 on top of the standard fee, And if they use that service, the application will be processed the next working day after their appointment. Then if we have a look at the out of country process, it's pretty similar. So again, first of all, the sponsor will need to assess whether the role and the person qualifies for sponsorship. If they do, they will need to request what's called a defined certificate of sponsorship. And so they'll need to make that request on their online sponsor license by providing a few details about the role, etc. And once they've made that request, it normally takes 1 or 2 working days for the request to be processed and granted. Once the defined certificate of sponsorship has been granted, the employer can then assign that certificate to them. And once that has happened, again, the process is pretty similar. The individual will need to submit their online form, they'll need to submit their supporting documents, and they will need to attend an appointment to give their fingerprints, etc. If the individual is applying from certain countries, they will also need to take a tuberculosis test to prove that they're free from infectious tuberculosis before they'll be allowed to get their visa. So for out-of-country applications, the standard processing time is 3 weeks. And again, there is a priority service, which this time costs £220. And if applicants use that service, then their application will be processed in 5 working days. And then just to wrap up the skilled worker route, so we've got here a list of all of the application fees, and you can see it gets quite expensive. So first of all, as Anna mentioned before, if you don't already have a sponsor license and you want to sponsor somebody under the skilled worker route, you'll first need to get your sponsor license. So that will be the £536 fee for a small company, or your medium or large employer fee of £1,476. And then on top of that, for each person that you sponsor, you will need to pay the fees shown on this slide. So there's the certificate of sponsorship fee, which is £199 or free for EU nationals. And then the immigration skills charge, which can add up quite a bit. So that, as you can see, that's £364 per year of the certificate of sponsorship for small employers, or £1,000 per year of the certificate of sponsorship for medium or large employers. So if you're a medium or large company and you want to sponsor somebody for 5 years, then you'll have to upfront pay £5,000 at the time that you assign the certificate of sponsorship. So it's quite a hefty fee. On top of that, you've got the immigration health charge, which, as you'll see at the last column in the slide, is £624 per year of the visa. And that's payable by the main applicant and also any family members that they bring with them. And there's a slightly reduced fee of £470 per year for children who are applying. And basically that cost is supposed to cover the cost of the individual using the NHS while they're in the UK. And then on top of all of those fees, you've also got the application fee. And as you'll see from the slide, the cost varies slightly depending on whether you are applying from inside or outside the UK. And also it will be slightly higher if you are applying for a visa that's more than 3 years. And I should say that people can be sponsored for up to 5 years in one go. So that those higher fees would be effectively for a 4 or 5 year visa. As you can see on the slide, the visa fee for shortage occupationist roles is slightly lower, so £464 for a visa of up to 3 years and £928 for a visa of 3 years or more. So as I say, there is a bit of a saving. Also worth flagging that there is a slight reduction, £55, so not a lot, but still a £55 reduction for applicants who are from certain EEA countries or from Turkey. Right, so now we've gone through the skilled worker route, I'm going to hand over to Anna so that she can talk a bit more about the creative visa.
Thanks ever so much, Liz. We will answer questions at the end. I can see that there's a lot of questions in the chat. Just to cover a few that I spotted. So, for example, the skilled worker visa route does apply to EU nationals who have arrived in the UK from the 1st of January 2021. That is a route that may well be useful to sponsor an EU national. That's the significance of Brexit, that these new visa routes will apply to EU citizens and can be used by EU citizens. We do recognise that a lot of studios are hiring remotely, and people will be based permanently overseas, so that doesn't involve any UK visa, but of course it will involve various employment law considerations, which we will be discussing at the end. So that is included as a topic in this session. And finally, access to be able to view things like the appendix skilled occupation, appendix shortage occupation. They are all on the gov.uk website under the immigration rules. So looking at creative and sporting visas, as you can see there, a creative worker is someone who can make a unique contribution to the UK's rich cultural life, for example, as an artist, which is what a lot of animators will come under, dancer, musician or entertainer, or as a model. So the purpose of this route is for those individuals who will make a unique contribution to the UK's cultural life. So looking at the key eligibility requirements for a creative visa now, so as you can see there, it is for roles in the creative sector, and they can be used for those shortage occupation roles that Liz showed you earlier. So for example, the artist route for animators, or CG supervisors or producers, they would all fall under those potential shortage occupation roles. Or this visa route can be used where the sponsor, the licensed sponsor, has applied what's called the Creative Worker Code of Practice, which is essentially looking at how that business has identified and recruited that non-UK national and identified them as someone that is most suitable for the role in preference over, for example, a non-UK national. Now, significantly, this temporary worker creative visa route does not have an English language requirement. So that's one of the key differences of this route, that whereas the skilled worker visa route requires, say, Pablo from Argentina to be able to have a minimum English language, well, the advantage of this route is that there is no English language requirement. And so if you want that CG supervisor to come into the UK even more quickly, and they don't have to spend 4 to 6 weeks booking an improved English language test, waiting for the results, then this creates a potentially more suitable visa route. Also, unlike the skilled worker visa route, there is no minimum salary, apart from, of course, to be paid the appropriate market rate for that role as set by PAT, the Producers Alliance, or BECTU, the Broadcasting Union. Like with the skilled worker route, there is also the same financial requirement that Liz discussed earlier, that it's either £1,270 or the licensed sponsor can certify on that certificate of sponsorship will cover their maintenance for the first month in the UK. So this route, as we said, it's a sponsored route, so they do need one of these all-important certificates of sponsorship. But it is not a route that leads to settlement in the UK. So whereas the skilled worker route, if you've been here for 5 years, you could then eventually apply to settle in the UK and get permanent residence. So this temporary route, like for example the student sponsored route, does not lead to settlement. So when we look at we're going to look at the end of this section at a case study, and it will be interesting to help sort of put some of these visa routes together and put it all into context of a real life scenario whereby you want to hire someone. So we are going to look at a case study shortly, which will hopefully bring some of these varied strands and different visa routes together, because we appreciate that it's a lot of information, and we'll do our best to make it relevant to a real life scenario. So looking at now, I mentioned earlier there is a creative worker code of practice, which basically means that before sponsoring someone, a licensed sponsor like an animation studio holding a sponsor license needs to comply with the code of practice, which is effectively to justify offering that role to a non-UK national. If the role is on the shortage occupation, they do not need to follow this creative worker code of practice, but it is still good practice to do so. So again, this is something that is found online, this Appendix T5 Creative Code of Practice, and it covers the various areas, such as you might have fashion models and ballet, and it's certain practices that someone must follow in their recruitment before they can issue one of these certificates of sponsorship. The most relevant of these categories to your industry is workers in film and television. And so, for example, you could have someone, the worker could be a senior creative grade. So this applies to roles such as a producer, director, a visual effects supervisor. So as long as the sponsor can show that this individual has the requisite skills and experience, then crucially that role is exempt from advertising. You have traditionally this resident labour market test whereby you have to advertise the role and then be able to show that no non-UK nationals were suitable or even applied. But you're exempt from following that advertising process if, for example, the person is of a particular seniority. Or what the Creative Worker Code of Practice also says is, well, if that role is highly specialist, well, when that means advertising is demonstrably not appropriate in the first place. So, for example, it could be someone with special effects experience, or that they know particular IT or technology skills to be able to perform that particular role. And of course, as long as that employer has kept a copy of the job description on file, someone's professional accreditation, someone's CV, it all helps show that we legitimately are assigning a cost to this person who, yes, is a non-UK national, but we did not find the requisite skills in the resident labour market from the local UK workforce. So it's just something to bear in mind. And we have clients that, although, for example, the role, an artist role is on the shortage occupation list, but on the certificate of sponsorship, not only can you say, look, this is a shortage occupation role, but by the way, it is also really highly specialist, and advertising is demonstrably not appropriate. So that's why I'm saying it's good practice anyway to follow this code of practice, even if the role is on the shortage occupation list. So that's looking at the eligibility and the application process for creative workers. But now it's interesting to just compare the fees, because as we said, sometimes if you do hold a sponsor license, there is a difference in cost between hiring someone on the skilled worker route and hiring someone as a creative worker, who both sponsored roles, but you can see that it's cheaper. The visa fee for a creative worker is £244. The certificate of sponsorship fee is significantly less at £21, and it's only the immigration health charge that the applicant would need to pay. Sometimes the employer is willing to help fund the costs for that migrant. So, but significantly, there was no immigration skills charge. So if you were a large employer that wanted to sponsor someone on the skilled worker route, say for 5 years, you're already looking at £5,000, £1,000 per year of sponsorship, which is a huge sum of money. Whereas the creative worker route, at least, does not have that very prohibitive immigration skills charge payable. So looking now at the creative worker visa process, Liz looked at it in detail for the skilled worker process. So I'm not going to repeat a lot of what she's already said, because there's a lot of things that are very similar. Applications are made online, you upload supporting documents, whether you're inside or outside the UK. Just one of the key differences, though, to recognise for a creative worker is that their very first application as a creative worker has to be made from outside the UK. You can't, for example, be here on a spouse visa and switch to a creative worker visa. That first application has to be made from overseas. But then once you're in the UK, you can, as a creative worker, you can apply to extend that visa for up to 2 years, so another 12 months, as long as it's with that same animation studio. But so I'd say that's otherwise you can have you can pay for priority processing services, and you get a biometric residence permit. It's a sort of credit card size document, and that's what you'd be looking at as an employer to comply with those right to work checks that Liz talked about at the beginning. So that is a very quick canter through the main sponsored routes for animation professionals, and as I'm sure that the sort of other you may have further questions, and we can look at that at the end. But as I say, we will do the case study shortly, but what we wanted to look at first is just the 3 main types of non-sponsored visa routes that you might come across people holding, or when they if they hire, if they apply to you and you want to hire them, they might say, well, hey, look, I've already got this type of visa. And so, for example, the first one, Liz, could be a global talent visa.
Thanks, Anna. So yeah, so as I mentioned before, the global talent route lets leaders or potential leaders in various fields, including arts and culture, come to the UK without being sponsored by a UK employer. So arts and culture includes film and television, and that specifically includes animation, post-production and visual effects. So it could be really obviously very relevant to someone in animation. So in order to qualify under this route, the individual needs to be endorsed by PACT for film and television. And they will also need to submit letters of recommendation and evidence of industry recognition, or of winning or being nominated for, or helping someone else win or be nominated for an Academy Award, BAFTA, Golden Globe or Emmy. So it's a route that's sort of aimed at the most talented in their field, you know, the very best. So it's a really useful route, because if somebody is able to qualify for it, they can work in the UK as an employee or as a director of a company, or be self-employed. They don't need to meet an English language requirement, which, as we've talked about, can sometimes certainly add to the kind of administrative efforts. You know, it takes a while to get it, even if somebody is already very confident in English. And it's also really useful because they don't need to earn a minimum amount in the UK. So as you'll have seen with particularly the skilled worker route, it's very sort of strict requirements about how much a person needs to earn, and you don't need to worry about that. And a major advantage for you as an employer is that if somebody qualifies for a visa under this route, it tends to be much cheaper. So the individual will need to pay an endorsement fee to get the initial endorsement of about just under £500. And then they will also need to pay an application fee of about £150, and they will need to pay that immigration health surcharge that we talked about before, so £624 per year of the visa. But that's sort of for them to pay, and they obviously don't need sponsorship by you. And that means that you don't need to pay the certificate of sponsorship fee, the £199 fee, and really importantly, you don't need to pay that immigration skills charge, which, as we said, can add up. If you're a large employer, that'd be £1,000 per year of the visa, so it can obviously be really expensive. So this is a great route if it's available. Another potential route is the Youth Mobility Scheme visa, and you may have come across these visas from time to time. So they are available to nationals of certain countries, and we've got the list of countries on the slide here, but it includes Australia, Canada, New Zealand, etc. And it is open to anybody who's aged 18 to 30 from, let's say, of the nationalities listed on the slide. And there's a sort of fairly relatively low financial requirements. They need to have at least £2,530 in savings. So that's a sort of, they've got to have more than, say, a person under the skilled worker route. But if somebody qualifies for this type of visa, then they will be issued with a 2-year visa that lets them come to work in the UK in pretty much any job, as long as it pays minimum wage. So it doesn't need to be, you know, super high-flying job or anything like that. They can do anything, or they can be self-employed, or they can study in the UK. So they are issued with a 2-year visa that isn't extendable. So it's kind of a temporary route, but it is very useful because the individual will need to apply for the visa themselves, again, relatively low application fees, and they'll also have to pay the immigration health surcharge that we mentioned before. However, again, because you won't be sponsoring them, you won't have to pay that large immigration skills charge fee. So it's a much cheaper route. And I think often this route, because it is only for 2 years, the person doesn't qualify for settlement. At the end of their 2 years, they'd need to sort of switch to a different immigration route to start building up time to settle in the UK ultimately. But it does give you as an employer a chance to perhaps hire somebody who already has this type of visa, try them out, see if you're impressed by them. If you are, then you can potentially offer to sponsor them under the skilled worker route, but it kind of lets you try the person out without having to sponsor them immediately. And so now I'm going to hand over to Anna, who's going to tell you a bit about the new graduate visa route.
Thanks, Liz. I did just spot in the chat, there was a question about whether the skilled worker route or the creative worker route can be used by if you're a freelancer. Well, unfortunately, the key about those routes are they are sponsored routes, and you need to have an employment relationship with your licensed sponsor. So basically, if you want to work as a freelancer in the UK, you're better off to be looking at some of these non-sponsored routes. So it could be that you're a freelancer, but you have a British spouse, for example, so you could work as a spouse on a spouse visa, or it might be that you qualify for one of these youth mobility visas. Though, just to answer another question I just spotted on the chat, unfortunately, the youth mobility scheme is not currently open to EU nationals. We did wonder whether it would be open to the 27 EU member states, but at the moment it isn't. It's just limited to, I think it's those 8 countries that are on Liz's slide. So unfortunately, Brexit has not produced a visa route just for EU nationals. In fact, there is not a visa route for low-skilled labour either. So that's why you're having to look at certain other visa routes, such as youth mobility if they qualify. Another visa route that we did look at the beginning was the Tier 5 government authorised exchange. So that actually is a route whereby an employer can sign up to an organisation like BUNAC, and they can have an approved sort of work experience scheme. And so BUNAC would be an overarching sponsor that could sponsor interns, for example, or to help with work experience. So that's just another visa route to bear in mind. But what I was going to look at now is the graduate visa route. So this is actually quite an exciting new visa route that has been lobbied hard for by the international student sector. So this visa route sees the revival of the post-study work visa. So where you might have heard of people on Tier 4 visas, which is the student visa route, now called student visa route, whereas at the moment, such people would not be able to stay on in the UK without having to find a sponsor to, for example, sponsor them on a skilled worker visa. However, the launch of the graduate visa route is really exciting because it means that those international students that the UK wants to attract can remain in the UK. So as long as they've completed a course at degree level with a licensed student sponsor, and that study was in the UK, they have the right from the 1st of July to apply for a graduate visa. And the reason this graduate visa will be really attractive to you as in animation studios is because it will allow that person to stay in the UK, non-sponsored, and work for you for up to 2 years, in fact 3 years if they did a PhD, and that can be at any skill level, in any role, at any salary. So it's providing a lot of flexibility, and it's going to be an influx into the UK workforce of highly skilled, highly talented graduates from UK universities. So that's a really exciting new visa route that will be that you will start hopefully seeing hires and applicants that are coming to you with from July onwards. So in a bid to try and put all these different strands together and all these various different visa routes, Liz is going to talk us through a case study.
Right, okay, so we've got an animation studio who wants to recruit Helga, a 25-year-old German national, and they want to recruit her as an animator on a 3-month contract, and they're going to pay her a salary of £20,000 per year. So she plans to arrive in the UK on the 30th of January 2021, so she's a bit late. So Anna, perhaps you can talk us through the options that might be available to her.
Okay, so thanks, Liz. So what we've seen through talking through the UK's post-Brexit immigration system is hopefully you can pick out from that case study just certain words that will immediately guide you to what potential visa route she needs to look at. So we look at the fact that she's German. That's really significant. We look at the role she wants to do, an animator role. We look at the length of contract she wants, 3 months. We look at the salary, £20,000, And finally, really crucially, what date did she arrive in the UK? So by breaking it down, the first point to note is because she arrived in the UK on the 30th of January this year, she unfortunately does not qualify under the EUSS scheme. She's a German national. Had she arrived on the 30th of December, 1 month earlier, she would have qualified and then had the right to remain protected, and she would be someone that would be very cheap to hire because you could just take her pre-settled status. So unfortunately, Helga falls into that second cohort of EU nationals who do not qualify for the EUSS scheme and are subject to the UK's new immigration system. So that's one of the first points to note. Liz, do you want to talk about whether she might qualify under the skilled worker route?
Yeah, okay. So as we mentioned for this skilled worker route, so in theory, that's a great option. It would allow her to be sponsored for up to 5 years in the UK, or for less if Animation Studio only wants her for 3 months, and that's also possible. So first of all, we would need to look at whether her role, first of all, has Animation Studio got a sponsor license, and we'll assume for these purposes that it does. Does she meet the English language requirement? So we would need to check whether, for example, she's got a degree from a UK university or had a degree that was wholly taught in English, or possibly whether she has a second nationality. So, for example, if she was a dual Australian national, then obviously she would meet the English language requirement in that way. If none of those apply, then she could meet the English language requirement by taking English language test. So the next thing to look at is does her role qualify for sponsorship? Now, as we mentioned before, that the role of animator does qualify for sponsorship, and it falls into occupation code 3411. So next thing to look at is the salary. Does the role meet the skilled worker minimum salary requirements? So as we said before, occupation code 3411 falls onto the shortage occupation list, which is great because it means you can offer a slightly lower salary. Well, so if we look at, first of all, the salary for occupation code 3411, that would normally be £21,000 per year, which would be obviously a problem here. But because Animation Studio could pay her 80% of that going rate, because it's a shortage occupation code role, they can offer a salary of £16,800 per year. Sounds great. However, unfortunately, as I mentioned before, the role needs to be to pay the hire of £20,480 per year, or 80% of the going rate for the occupation code. So unfortunately, the salary here doesn't look to be quite high enough because it falls under the £20,480 minimum salary requirements. So Animation Studio potentially could go ahead with the sponsorship if they thought it was worth it for a 3-month contract. But if they wanted to, they would need to think about increasing her salary slightly so that it met the skilled worker requirements.
And what they could do as an alternative, if they also hold a sponsor license in the creative worker tier, which we would always recommend if an animation studio was going to apply for a sponsor license, it doesn't cost any more to also tick the box to say, yes, we'd like a skilled worker license as well as a creative worker license. And so the advantage of sponsoring her, which may well be more appropriate on the T5 creative worker route, is of course there's no minimum English language requirement, and also no minimum salary, and it's kind of more designed for these short-term contracts. So I mean, Liz has talked you through the skilled worker route, but I think that a creative worker visa type here would probably be most suitable, provided that they have a sponsor license, because as we know, the animator is on the shortage occupation list, but also the animation studio could say, well, you know, Helga's got these really specialist skills, and there's no point advertising in the resident labour market in the UK. We're not going to find this skill in the UK. So so that's why you can kind of start seeing the flexibility of having a sponsor license, but b a sponsor license in these two potential tiers that could help you hire these animation professionals. But also, so my question now, Liz, is how would our answer differ if Helga actually was from Canada?
So yeah, so if Helga was from Canada, we've got a couple of additional potential options that might be open to her. So first of all, I'm not sure if you remember, but near the start of the talk, I mentioned the ancestry visa, and that's open to Commonwealth nationals from Commonwealth countries with a British-born grandparent. So we would ask Helga, so Canada, she could potentially qualify because she's a Canadian national. So we would ask her, does she have a British-born grandparent? And that would be a really useful visa route in theory if it works, but often it's not really an option. So the other potential option would be the Youth Mobility Scheme visa, which, as we mentioned before, is open to nationals of various countries, including Canadian nationals. So we'll have a look at Helga's age. She's 25, so she does fall within that 18 to 30 age bracket, and so could potentially qualify for a skilled worker, a Youth Mobility Scheme visa. So if she was able to get that visa, then she would be able to get it on her own. She wouldn't need sponsorship from Animation Studio, and it would let her come for up to 2 years in the UK. Obviously, Animation Studio only wants her for 3 months, but it might be that the studio actually really likes her, wants to keep her on for a bit longer, or if she wanted, I suppose she could go off and look for other jobs in the UK after she'd finished that 3-month contract if she wanted to, because she wouldn't be tied to a particular sponsor.
Brilliant. Well, thanks ever so much, Liz. So what we were going to look at before we wrap up and open to questions is this idea that I know a lot of you are experiencing at the moment, is that because of the pandemic, more and more people are being hired to work remotely from overseas. And as we mentioned, that doesn't then entail having to check they've got the right visa to work in the UK, because they are not physically in the UK. But what Liz is going to look at now in one of our last slides is what the employment considerations should be in that scenario when you are hiring remotely from overseas. So over to you, Liz.
Great, thanks, Anna. So as Anna mentioned, I'm going to be talking a bit about considerations when hiring remotely overseas. And I think we've seen lots of companies, animation studios and other organisations are, well, they're sort of taking different approaches. So I think some organisations are happy for people to continue working remotely overseas. So in Spain, for example, for the moment, so they want to bring them over to the UK ultimately, but they're happy for them to work from home while the studio is closed and while there are sort of COVID restrictions in place, and perhaps the person doesn't want to come to the UK for the moment. So there's that category, but I think also lots of organisations are sort of thinking a bit more about whether actually it's quite possible to have employees working remotely overseas on a sort of long-term or permanent basis, whether they can do the role just as well from home in, again, say Spain or wherever. So we've put together a list of considerations, so it's sort of a kind of a brief overview of things to just bear in mind when you're employing remotely overseas. So first of all, really important, take local employment law advice. So if someone's working for you overseas, then they may gain employment law rights in the country that they're working from. And that's particularly likely if they're going to be working overseas on a sort of long-term or even permanent basis. So we'd really recommend that you speak to a local employment lawyer in the country that they're in, just to check that their employment contract complies with local employment law requirements, and that there's just nothing unusual, I suppose, in local law that you'd want to be aware of. Similarly, if you decide that you want to terminate the person's employment, then again, take local employment law advice just to check that you are following local due process and that you're terminating for a reason that's considered valid under local law, just to make sure that you're not exposed to any claims. Second, sounds really obvious, but agree on the practicalities from the outset and make sure that they are documented. So if, for example, the person will be working in a different time zone, are you happy for them to, or rather, will you require them to work a 9 to 5:30 p.m. standard working day, or are you happy for them to be a bit flexible? Will you require them to come to the UK every quarter for a staff meeting or to come for client meetings? And if you are going to require that, who will pay for their accommodation and their travel? Will you still require them to come if the COVID self-isolation requirements on entry to the UK are still in force? Think about that sort of thing, agree it with the individual in advance so that there's no ambiguity, and make sure that it's reflected either in their employment contract or potentially in a side letter. And then that means that you can turn to it if there's ever any dispute about what was agreed in the future. Similarly, think about any health and safety measures. So how you're going to comply with your health and safety obligations. Are you going to ask overseas employees to fill in a health and safety questionnaire? Are you going to provide them with sort of equipment that they need to work safely, even though they're overseas? Third sounds really obvious, but make sure that their employment contract reflects their correct work location. If the plan is that they will be working permanently at their home in, say, Spain, make sure the contract says that. Equally, if actually the idea is that they will initially work from their home country while the COVID measures are still in place, the UK is still in sort of semi-lockdown, but you ultimately want them to come to the UK to work permanently in your UK office or your studio, etc., make sure that the contract says that. And that can also be helpful from a Home Office compliance perspective. So if the Home Office ever carried out an audit of your premises, then they saw this employee's contract that said that they will be based in the UK, working in the UK, then the compliance officer might sort of raise questions and ask whether you're illegally employing somebody that doesn't have the right to work in the UK. So if you can point to a contract side letter that says, your normal place of work will be your home in Spain, then that would be helpful to be able to show them that. And on a similar sort of note, ideally pay the person's salary into an overseas bank account, again, to show, if the Home Office ever asks, that you are employing the person outside the UK, that they're not working for you in the UK without the right to work. Next, we recommend that you check your insurance policies, because often they may only cover employees who are physically based in the UK, and so it's good just to check that and make sure that you're covered. Then consider the potential data protection implications of the person working overseas. So will the person have access to personal data, for example, about colleagues or customers or suppliers? If so, that data will be covered by UK data protection laws, and there could potentially be overseas data transfer implications if they're based outside the EEA. I think that the ICO, the Information Commissioner's Office, has indicated that it should be okay if the person is employed by you, but it's definitely worth taking specific advice, on the particular circumstances in advance, and not least because that could change, that position could change. And finally, really important, take tax advice. If the individual is working from home outside the UK, then there could be personal tax implications for them. But there could also be payroll tax or social security withholding obligations for your business. And depending on where the person is, the role that the person is doing in your business, their presence in another country could potentially create a permanent establishment of your business in that other country. So we aren't tax advisors, so we can't provide sort of specific guidance on that, but it's just worth bearing in mind, and definitely worth taking tax advice before you agree to this sort of arrangement, to make sure that you understand what you're agreeing to, so that you don't get any nasty surprises later on, and also so that you can sort of make sure that you do everything in the kind of the correct way, and in a way that protects your business. So I think those were the main points that we wanted to cover. So I think the next point is any questions.
Brilliant. Thanks so much, Liz and Anna. That was really wonderful to get that overview. I've got a few questions for you that have come up on the chat. So the first is, there's two questions that relate to the global talent visas. So one of them is a two-part here, is, in terms of the awards, were the ones that you showed the only ones that can be used as proof, or do also things like the Annie Awards or the Visual Effects Society Awards count? And someone else asked what is considered as proof of industry recognition other than award nominations. Is there somewhere that people can look to get the kind of full overview of the requirements?
Yeah, so we can certainly provide, yeah, you can find that information. I think that's probably best rather than us kind of going through the specific, because it's one of these things. I think the immigration rules are so specific. I don't want to kind of give a general overview talking, because it's one of these things where if you don't follow the exact letter of the requirements, the Home Office could reject it. So yeah, we can, it's certainly available online, and perhaps we can
send
maybe
a link to
share
the,
link.
there's various guidance about
Exactly.
much more detailed guidance about global talent visas and what industry recognition would work and would count, and what other awards would count. So yeah, we can certainly drop a line perhaps to Abigail afterwards, and you can forward that on.
Yeah.
Brilliant, thank you. Just had a question. Can we hire people overseas as freelancers under English law?
Sorry, is the question that the freelancer would be based overseas?
Yes.
So is that coming back to your point, Liz, that there might be, so local employment law obviously would be relevant in that scenario, but would English law apply?
I think it would, in that situation. It's one of these, it's a slightly kind of weird situation. So I think in principle, I think that would, in general terms, from a UK law perspective, I think that's fine. But I think it would be a case of taking local employment law advice, and the extent to which any relationship like that was governed by English law would depend on sort of the proximity of the individual to the UK as to whether English employment law rights and sort of definitions of freelancer or employed, self-employed, etc. applied. As I say, would depend on whether they had any, whether they were ever working together, basically the closeness of the relationship to the UK. But I suspect in that kind of situation, it would be a case of taking certainly local advice just to check that the arrangement complies with any local obligations.
Okay, thank you. A question from a studio about if you have someone who is already on a tier 5 visa that runs out this autumn, and they want to continue to sponsor this person but switch them to a skilled worker visa, does the person in question have to leave the country to apply for the skilled worker visa? And if so, does the studio have to carry out a resident labour market test? A complicated question.
No, that's actually made less complicated by the new immigration system, that whereas there used to be quite kind of specific rules about when you can switch from a visa type within the UK or when you had to go home. So in fact, if they are currently here on a tier 5 visa and that employer does have a sponsor license in the skilled worker category, they can assign them a certificate of sponsorship and they can switch from a tier 5 visa to a skilled worker visa. As I said, the only time that you couldn't switch and you would have to return home to apply overseas is if you were here on another visa type, say youth mobility, and wanted to be sponsored under this tier 5 creative worker. The very first visa you get under that route, you do have to apply from overseas. But to answer his question, that person should be able to apply from within the UK, so save flights and quarantine and COVID-19 travel restrictions and taking a test to get into the UK. So yes, much better to apply from within the UK in that scenario.
Okay, another question for you. If we have a 25-year-old, this is like a sort of math test. If we have a 25-year-old Spanish junior animator who is turning 26 in August, working for us on a full-time contractor basis since last September, on a salary of 21,000, and they are currently living in Spain, but they want to move over to England once they're fully vaccinated, what is the best route for this person to apply?
Okay, so I guess one of the first questions would be whether now if this person is a Spanish national and if they've got if they haven't been in the UK by the 31st of December, nor a historic period of residence, because sometimes someone can have been living in the UK a while ago, but could still actually qualify for pre-settled status. But if this Spanish national has just never set foot in the UK before, then the key point to note is they are going to be subject to the new immigration system. And so this animation studio is going to either have to look at the sponsor license route, so getting a sponsor license in the first place, which you can do quite easily, and they're processing applications quite quickly. So this animation studio, I probably would recommend getting a sponsor sponsor license, because then that Spanish national could be sponsored either under the skilled worker route, which may well be appropriate if they want to hire him in the long term. But of course, that Spanish national would need to satisfy an English language test, or you look at the creative worker visa route. Otherwise, you look at whether the Spanish national has any other ways to come to the UK, whether, for example, they might have a British partner, for example, or whether they qualify under some of the other visa routes that we were talking about. Or if they come to study in the UK, a student holding a student visa is allowed to work 20 hours per week part-time during term time for a UK employer, and then when it's that student's holidays, they can work on a full-time basis.
I was just going to mention, just to add to sort of what Anna said, and I know Anna obviously talked all about the sponsor license application process before, but just something that's really worth flagging is that if you think you might want to sponsor somebody under the skilled worker route, or actually any of these sponsored routes, it's definitely worth applying for a license sooner rather than later. So at the moment, sort of last year when no one was applying for sponsor licenses, they were whizzing through the applications, taking two or 3 weeks, whereas now sort of standard processing time, I think, is 6 to 8 weeks. So if you think you might want to, and I should say there is a priority service that people can use to speed up the processing of the application. But I think they're only sort of taking 10 a day, so they're like gold dust. So you definitely don't want to be relying on the priority 10 working day route. And so it's just to sort of mention, if people are thinking about it, it's definitely worth factoring in that 6 to 8 week timeline, rather than just assuming, waiting till a month before the person wants to come and then suddenly panicking and think, oh, better sort out their visa.
Maybe this is a good point to draw it to close while everyone's still processing everything that you've just shared this afternoon. Thank you both so much, Liz and Anna, for this session. It's been really, really brilliant to hear all of this, this complex world that we're all going to be navigating. So thank you very much for joining us, and goodbye.